Hello, my name is Crystal Dahl, and I am the Online Communications Manager here at Meritas. I would like to welcome and thank each of you for joining us on today's webinar. For those of you new to Meritas, Meritas is an established global alliance of closely connected yet independent law firms that each offer a full range of highly quality, specialized legal services. We were built upon a rigorous system for monitoring and enhancing the quality of our member firms and have been connecting clients with carefully qualified business legal expertise in over 240 markets around the world since 1990. Meritas Capability webinars are regularly presented by Meritas members. Before we get started, I would like to go over a few housekeeping items. Meritas offers the ability to listen to the audio through your computer speakers, but if at any time you have any difficulty hearing the presentation, you may call into the associated telephone line instead. All of phone lines will be muted. If you experience any technical difficulties, please press *0 at any time to connect with a support technician, or you can use the chat feature to connect with me directly. That chat feature is found on the left-hand side of your screen. Since you will be muted, please use that chat feature to ask any questions. Joel plans to answer his questions throughout the at the end of the presentation. Lastly, in the next few days, I will distribute a copy of the presentation, a recording of the webinar, as well as Joel's contact details. Our presenter today comes from the Meritas member firm in Pittsburgh, Pennsylvania. Joel Pfeffer is a partner of Meyer, Unkevic & Scott. He is chair of the Corporate and Business Law Group and a member of the International and Immigration Law Group. Mr. Pfeffer works primarily in the areas of immigration, nationality, and corporate law. With that, Joel, are you ready to get started?
I am. Thank you very much.
You're welcome.
Okay, I'm Joel Pfeffer, and I'll be talking today about the U.S. immigration, the Trump administration's new normal, which I have subtitled The Invisible Wall, because that is essentially what the administration is seeking to create here by creating difficulties for foreign nationals to enter the United States. I will cover basically the four issues that are on this slide: an overview of several non-immigrant, which means temporary programs available for business application, a brief background on permanent resident status and how the Trump administration has changed the way that that is processed. I will talk about in that context, I will talk about proposed regulations that change how public charge determinations are made. That means that for every immigrant and even non-immigrant who enters the United States, somebody, either a consular officer or someone at the Department of Homeland Security, must determine that this person will not become a public charge, which typically means will not go on government programs. And the Trump administration, I believe it was last month, the comment period ended yesterday, I believe, has proposed new regulations for that process. Then I'll talk a bit about the travel ban. And then in the end, I will share with you a hypothetical business situation that calls for some solution. Somebody wants to come to the United States to manage a business, and we'll run through the solutions or the non-solutions that are available in that case. Okay, to begin, non-immigrants. The most popular program in the non-immigrant world to send somebody to the United States to be employed on a temporary basis is the H-1B program. Now, when President Trump became president, he issued a presidential executive order or proclamation called Buy American, Hire American, and said that his administration is going to focus on bringing employment up and making it more difficult for foreigners to take U.S. jobs. And the first place that his sights were focused were on the H-1B program. By way of background, the H-1B program requires an employer, typically a business, that has the ability to pay the salary and has some kind of track record. They typically ask gross and net income, number of employees, how long have you been in business, and other than that, you should be prepared to the client should be prepared to volunteer other information about what they do. In order for the foreign national to qualify, the position must be a professional position. The foreign national must be at professional level employee. Now, that's not the same as the position. If the employee has a degree, that does not necessarily make the position a professional position. It's important to establish that this position is professional in the sense that it requires the application of principles that are taught at the post-secondary level. And the salary must meet what's called the prevailing wage, which is typically established by the Department of Labor. We'll get to that in a moment. Unfortunately, there's an annual limit, or what we call a cap, on H-1B availability. The limit is 65,000, and there are 200,000 additional U.S. master's graduate slots. So basically, there are 85,000 slots. During the Clinton years, there were more. I think there were even over about 140,000 at one time. But I think in the Bush years, it was reduced to these numbers, and it's been this way for quite a while. Now, I would say probably 5 or 6 years ago, there began to be a demand for these slots, and every year now we have what's called a lottery. There are about 200,000 applications for the H-1Bs, and there are only 85,000 to go around. Now, I'll come back to how those are selected in a moment. The one issue that we have seen some changes from the Department of Homeland Security is the prevailing wage. The prevailing wage means that you must establish that you are paying the salary that is being paid is similar to what individuals in this profession make in the community. The U.S. Department of Labor publishes survey information or publishes prevailing wages, and typically employers look to those wages to establish that they are paying enough money. The Department of Labor has 4 levels, entry through level 4, and in recent years, including last year, we saw a high degree of scrutiny, particularly if you submitted an application with a level 1 wage, a Department of Labor level 1 wage, or even a level 2 wage. The U.S. Department of Homeland Security would challenge that and say, well, that's not really a professional. He's only making a level 1 wage. Frankly, that's not true. He's making an entry-level wage, and entry-level professionals qualify for H-1Bs. But nevertheless, that didn't stop the Department of Homeland Security from challenging these cases and issuing denials when they felt that the response to the challenge did not overcome the challenge. So we've seen quite a few denials where employers are paying entry-level wages even though they are relying on Department of Labor statistics. We expect that trend to continue, and employers need to be aware of that. The second thing that the Trump administration has decided to do here is propose procedural changes. In prior years, I'll go to the second one first. In prior years, the 20,000 master's cases were selected first from among a pool of applicants who had master's degrees from U.S. universities. Then the ones who were not selected were placed in the 65,000 pool and had a second shot at doing this. This year, they are proposing to reverse it. Whether the regulations will actually take effect for this coming year's lottery, which takes place on April 1st, remains to be seen. But they propose to do the 65,000 first and then the 20. The result of that will be that master's graduates will have a higher chance of success of being selected in the lottery because the 65,000 will contain more master's graduates than if they did it the other way. Some people are not happy about this, but I expect that the Department of Homeland Security will change this procedure and do the 65,000 first. They will also are talking about changing the process to simplify it in the sense that companies that want to participate in this lottery will register, will be selected, and once selected, then they will can prepare and file their petitions. In previous years, the petitions had to be prepared, and a company would spend money on preparing those petitions, whether or not you were selected. Okay, the lottery takes place in April, and the employment can begin as early as October 1st. So that's an overview of the H-1B option, and those are two changes that we've seen over the last 2 years in processing those cases. Let's move on to the L1. L1s are available for multinational transfers, people who are employed by a multinational company for at least 1 year during the 3 years prior to application. They are employed in an executive, managerial, or specialized knowledge category, and they are coming to the United States to work in an executive, managerial, or specialized knowledge category. Now, prior to the Trump administration, during the Obama years, the USCIS, the government bureau that is the arm of the Department of Homeland Security that adjudicates these cases, they published a policy memorandum defining what is specialized knowledge. And it has to be unique in the company or unique in the labor market. And they expect you to send in reams of evidence to prove that. Typically, we have to address how many people in the company can actually do this work. Is there a market? Is there a U.S. market for this? Are there employees available in the U.S. labor market who can do this work? And anything that appears to the government to be commonly held skills or lack complexity or easily imparted from one person to another will receive a challenge or a denial. That policy continues in the Trump administration, and we don't see any change in that. Just to give you a perspective on what that means, I would say that prior to that memorandum or prior to the policy being instituted, it would take an attorney about maybe 2 or 3 hours to put together an L1 petition. Now, it takes between 5 and 10 hours to put it together because the level of documents that you have to submit is so much greater in order to get over this challenge. In a sense, the same is true about filling a managerial or executive position. The government is demanding org charts. Org charts are very helpful in establishing who's a manager and who's an executive. I'd say the org chart is probably like a picture worth 1,000 words. You could talk about it for 1,000 words, but the picture will define the picture of who this person reports to, who reports to them. Typically, when there are professionals reporting to somebody, that person will be classified as a manager and qualify for the L1. So L1 remains a valuable tool for U.S. businesses seeking to bring foreign talent to the United States, but we can expect a continuation of the policy that seeks to limit who can come and the level of evidence that is required to establish qualification for the L. Now, the process for an L, the petition is filed with the U.S. Citizenship and Immigration Services, where this level of scrutiny that I described is common. It's to be expected. This is going to be a high level of scrutiny for an L1 case. I would say probably 2/3 of the L1 cases, at least 2/3, get a challenge. They're not approved without a challenge, without a request for evidence. Exceptions are when a company has what's called a blanket approval. If a company has $25 million in gross sales and 3 U.S. or foreign subsidiaries, there's got to be at least one outside the country, then they will require, then you can be approved for blanket approval, and the application can be made directly to a U.S. consulate abroad. U.S. consulates abroad, at least at the moment, I don't expect this to continue forever, but at the moment, they understand the need to transfer foreign talent from abroad to the United States, and they are much more liberal about what they define as a manager or as specialized knowledge. For example, in the United States, when you do this at the U.S. Citizenship and Immigration Services, you will always have to submit a list of weekly duties of your manager, executive, or specialized knowledge, assigning time slots, how much time is spent on these duties every week, and they're scrutinizing them to see whether or not this is in fact a managerial position. Is this person doing managerial duties? We don't typically see that at the consulates. But we are seeing an increase in the frequency of rejections at the consulates, and Canadians who can apply directly at the port of entry, with or without a blanket approval. Also, we're seeing a high level of port of entry questions. It appears that port of entry officers who adjudicate Canadian L1s have been trained by the Department of Homeland Security and are now applying the memorandum meticulously to the cases. Okay, that's H1 and L1, the two most used non-immigrant options to bring foreign talent to the United States. A third is TN. TN is under the NAFTA treaty, Mexicans and Canadians who are in a published list of professional occupations. There's a list of, I don't know, probably 100 occupations that you can qualify for a TN. If your employee is a Canadian or a Mexican, they can qualify. There's no quota, there's no cap, there's no requirement that there's no prevailing wage, there's no requirement that the person have worked outside the United States for your company in the last 3 years. It's just a matter of, is there a business opportunity for this person, and do they qualify as a professional, meaning do they have a degree in the field that is on that list. Mexicans need to apply at consulates, Canadians can apply directly at the border. And the big news, of course, is that all the talk about NAFTA did not affect the people part of NAFTA. So TN status remains available under NAFTA. Permanent residents, a green card. These others were temporary. A green card is available. Typically, a green card process involves establishing to the satisfaction of the Department of Labor that there are no U.S. workers available to fill the position. That is done by advertising the position and showing that you've done. There's a regulation that controls this. The regulation says what media you need to advertise in, and you have to show that you did that. The application is filed electronically, and it's like your tax return. The government can audit your work and ask you to show proof that you made this effort and who applied and why did you interview people who were potentially qualified and who did you reject and why. That's step one. Step two is proving that the employer and the employee are qualified. The process at that point moves to the Department of Homeland Security, where the employer has to show they have the ability to pay, that all of the requirements for the position are met by the employee, and that the employer is ready, willing, and able to employ the new employee in a permanent, ongoing basis. The third step is adjustment of status. It is if the employee is in the United States in one of these other statuses that I talked about, then they file an application to establish that they don't have a criminal record, they make enough money, they're going to be able to support themselves, they don't have a medical disability that disqualifies them, they don't have they don't take drugs, they're not habitual drinkers, those kinds of things. So it's basically a three-step process. I bring this to your attention because what the Trump administration has done is they have said that they want to see enhanced vetting of all permanent residents coming to the United States. This affects the employment process because until Trump came in, these cases were not interviewed. They were just processed in these three steps that I described, and that was considered sufficient vetting of the person. The Department of Labor vetted the case, the Department of Homeland Security vetted the case at two different levels, and typically interviews were waived. But the Trump administration has decided that they want everybody interviewed. So even the highest level managers, the highest level employees of the most sophisticated employees and their families must be brought to the Department of Homeland Security office, the USCIS office, and interviewed. Even children, they do what they call ID them. They ask them their names. Sometimes they ask them who your parents are. Parents are sitting right there in the room. They say, what's your parents' names? Where do you go to school? It's a little bit bizarre, but that's what they're doing. It's also creating backlogs that didn't exist before because the government is having difficulty handling the number of interviews that were previously waived. Okay, so that's what's being done with permanent resident aliens for businesses. In the family world, we have two kinds of visas. We have two kinds of processes. We have non-quota, unlimited number. If you're the spouse, child, or parent of an adult U.S. citizen, you can come to the United States just by filing papers and being interviewed. Spouses were always interviewed, but now even parents are being interviewed. And there are quota cases. There are 4 quota categories. You see them here on the screen. Unmarried sons and daughters. Sons and daughters means people over 21. Children means people under 21 in the immigration world. Unmarried sons and daughters of U.S. citizens, spouses, children, unmarried sons and daughters of permanent residents, married sons and daughters of U.S. citizens, and brothers and sisters of U.S. citizens. There are significant delays in many of these quota categories. There are no delays in the non-quota category. Now, here's the big news. The Trump administration has proposed changes to the regulation that governs public charge. Everybody, both business immigrants and family immigrants, and even technically non-immigrants, need to have there has to be a determination that they will not go on public assistance. These are the factors that will be considered. Now, these factors are already in the statute, but under current law, the way this is handled is that the government looks at what the salary is that an employee will make, and what the earning power of let's say, for example, you have a spouse case. They will look at the earning potential. What does the U.S. citizen's petitioning spouse earn, or if the beneficiary spouse has a job, what do they earn? Once you get over a certain level, 125% of poverty, you're in. It's an objective test. Once you meet those requirements, they don't look at it further. The Trump administration is proposing that we scrap the objective test and we go to a subjective test. Will it be likely that this person who's immigrating to the United States, or even theoretically coming as a visitor, will ever need government assistance in order to live in the United States? Now, the timeline that they're looking at is 5 years. The factors that are considered are age, health, family status, assets, resources, financial status, education, and skills. Those are the statutory ones. The proposed regulations also discuss language, although, frankly, there are certain languages that you might need to get a job in America other than English. But the point is that the Trump administration is proposing to change this from an objective test, do you meet a certain income level, you're in, from an objective test to a subjective test where a consular officer or an immigration officer is going to have to determine whether or not you're going to meet the requirements or ever have to go on welfare. So things that they're going to consider are, number one, the affidavit of support that we have today. If you have an affidavit from a family member, then, okay, what's the likelihood? Who is this person? How is he related to you? What is the likelihood that they're actually going to provide the support you need? I believe that this is going to have a dramatic effect on the system. It will technically affect non-immigrants and permanent residents, both. It will technically affect non-immigrant extension applications. It will certainly affect employment-based immigration, and it will certainly affect family immigration. And I believe that we will be facing a system where it will be totally unpredictable how a particular officer will view a particular set of facts and empower that officer to approve or deny the application and the permanent residency of the employee or family member. Okay, these are the visa backlogs for employment visas. If you have an employee from India, you're looking at 9 to 10 years till the green card process is completed. China, 3 to 4 years. Philippines, 1 to 2 years. Other countries current. I don't believe I put up here the backlogs for family, but they are significant in all categories. Okay, let's talk about the travel ban. The travel ban was part of the Trump, the first weeks of the Trump administration. There was a travel ban. There was the travel ban wound its way through the court system. Ultimately, the Supreme Court said, okay, the travel ban as it exists now is constitutional, and the countries that are affected are on this list here: Iran, Libya, North Korea, Somalia, Syria, Venezuela, and Yemen. Each country has a different class of people that it affects. We recently had a situation with an Iranian who had been in the United States. He wasn't subject to the travel ban, but they refused to. They just refused to approve his green card after we'd gone through the process I described earlier, and frankly, he had to sue the government in a mandamus action to get action. We just had a case approved from Syria with some question and some delay. Okay, those are the countries affected. There are exemptions for dual nationals, for U.S. permanent residents who are citizens of those countries, for diplomats, and anybody who was in the United States when the ban was first came out. Okay, and then there are waivers. In order to get a travel ban waiver, you have to show undue hardship, that the entrance into the United States is in the national interest and is not a threat to national security. I really can't define any of those because I don't believe there's much history yet on what those mean. Those are determinations made by consular officers at the U.S. consulates abroad. Let me talk to you for a moment about a hypothetical situation and perhaps review some of the concepts that we talked about. And I am watching the chat board. If anybody submits a question, I'll get to it as soon as I'm done with this hypothetical. I don't believe there are any questions yet. Just let me check. Oops. Well, what do I do? I'm sorry, I turned off my computer, so I can't see. I accidentally did that. So let me talk about the travel ban, the hypothetical. We recently had a situation where a company came to us and asked us if they were purchasing a steel plant in the United States and were seeking to employ they were Germans buying the steel plant, and they were seeking to employ a United Kingdom citizen to run it. And they asked me, okay, how do we get into the United States? So I went through the process with them of describing what the categories are. So, for example, H-1B. All right, it is now November. The lottery doesn't, or December. The lottery doesn't take place until April for October 1st employment. That's a long time from now. There are 85,000 slots and 200,000 applications. Even if you get in, even if you apply in April, you can wait till next October. You may not get in. So it's not a very viable option, but it may be the only one available. Intra-company transferee, L1 that we talked about, only available if the individual manager worked for your company abroad for 1 year within the last 3. That wasn't the case here. So that's really not available. TN, the person wasn't Canadian. The 2 that we did not talk about, O1, that's a visa for extraordinary ability aliens seeking to come to the United States to fill an extraordinary ability position. If this person could establish that he is the greatest of steel plant managers, maybe he can get it. The one that typically comes to mind is something called a treaty trader or treaty investor. That is available for citizens of about 80 countries who have the same nationality as the owner of the company. The company has purchased a steel plant. They would qualify as an investor, but the nationality has to line up. So Germany is one of the 80 countries, and the UK is one of the 80 countries. But since the manager and the owner are not the same country, they don't qualify. So really what I responded was the person has to try to run this business from abroad and try to enter the United States on occasion as a business visitor seeking to come here for perhaps 3 months at a time to basically meet people, gather information, and do what he needs to do to run this business from abroad. Not a very practical solution. In general, this hypothetical that I've given you, where a German company buys an ongoing U.S. business and wants to put its managerial staff in place, and they are not German, is going to be a real problem, and employers need to be aware of that. There is no real viable way to get somebody to get entry to the United States for that purpose. Okay, I have concluded my presentation, and I'm happy to take questions, but since my computer got knocked off accidentally, I'm going to need Crystal's help here.
Yep, I can read them to you if they come in, but I haven't seen any yet, Joel. So
okay, all right. So let me just respond to one question that I do typically get in this context of discussing the Trump administration initiatives to create this invisible wall, and that is when you have a quota from India, for example, where somebody's waiting 8 or 9 years to get to the end of the line and get their green card, and they can continue to get their H-1B renewed over that period of time, the Obama administration made it possible for the spouse of this applicant who was in the United States working in H-1B but waiting for his visa green card to become available in the quota system for a period of up to 9 years, made it possible for their spouse to work. The question that is constantly presented to me is, will Trump change that so that spouses will not be able to work? Most people think the answer is yes, he will change it, but no one knows when. So far, nothing has happened on that score, but it certainly has the Indian and Chinese community all nervous about the ability of spouses to work while their employee spouse is waiting for his or her green card to become approved. Okay, any questions there, Crystal?
Nope, none have come in. So
all right.
Thank you, Joel. As always, that was wonderfully done. Before we sign off, I just wanted to remind each of you that in the next few days I will distribute a copy of the presentation, a recording of the webinar. Please feel free to share that with others in your firm, at your companies, or with anybody you may think would find that of interest. I will also share Joel's contact details. If a question comes up in the meantime, please don't hesitate to reach out to him directly. I'm sure he'd be happy to answer any questions. And with that, thank you again for taking time to join us, and thank you, Joel. I hope everybody has a great day. Yep, thanks.
Okay.
Bye.
All right, bye-bye.